We leveraged the technology that we delivered such a good result, avoided trial, avoided exposure on behalf of a highly collectible insured in a pretty high multi-million-dollar case. Every time you take in a case, it's always like it's your first case ever. A really inefficient way of doing things. However, if you sort of conceptually threw all these cases on a whiteboard, there's commonalities between them. Let's say you have a client that doesn't agree with the use of AI, and you pull up Google and you type in your Google search. The top third of Google is a Gemini-assisted summary of the response. So it's using AI. Do we have to turn off the Gemini assist in Google for the firm? Ultimately, what we do as lawyers is still at its heart human connection. Our jobs are not going anywhere.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a rare triple threat in the legal world, a partner at Roig Lawyers who combines the mind of an industrial engineer, the business acumen of an MBA, and the skills of a seasoned litigator. He puts this unique background into practice by consulting with businesses and attorneys on how to leverage technology to increase efficiency and manage risk, and by spearheading his firm's AI development. It's my pleasure to welcome Mark Rose to the podcast. Welcome, Mark, and thank you for being here.
Thank you for having me. I appreciate the opportunity.
Yeah, well, thanks for being here again. Mark, as you know, I like to start every podcast episode with our guests sharing either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
I'll do a fun fact. This was a bit of a challenge. I realized maybe I'm not that fun, but I guess a fun fact about me. In my 20s, I got, I'll admittedly say, a little bit unhealthy, and it was a bit of a rude awakening, and I got very into fitness, and I actually was a CrossFit coach while I was a partner at the firm here and was coaching CrossFit classes for years. So I guess the triple threat, I was a quadruple threat, also coaching fitness.
That's amazing. I mean, that is, talk about diversity of experience. Wow. The MBA and the engineering wasn't broad enough, but you had CrossFit coach. And I know that you have an interest in automobiles and cars too, which we spoke about. So can you share a little bit about that?
For sure. Yeah, I love cars. I'm a car enthusiast, and it's hard to get those opportunities to go out and go do the really fun stuff, drive them on a track. But I guess that's one of those things. From a kid, I've always loved cars, and now it's cool having a son to try to get him into it as well.
That's awesome. Cool. So with that, let's move into your story, right? So I think of every attorney who makes the time to be on this podcast as a superhero, and every superhero has an origin story, and I know yours has many facets to it. So could you please share that?
Sure. Yeah, I think it's an interesting story, and I guess I go back to being a really little kid. I grew up with just my mom. She was an incredibly hard worker. And I think from an early age, like many lawyers, a smart little kid who is good at talking, your parents say, oh man, you should be a lawyer when you grow up. And I probably had that little bit of a ingrained in me as a kid, but more realistically, I saw that my mom was an incredible advocate, and that navigating through life, you need an advocate or to advocate for yourself. So that was really, I think, eye-opening as a young kid. And I progressed through school, and I'm going to University of Pittsburgh for engineering. Maybe the car thing. I love engineering. I love art too, actually. And so I had in my, I guess, junior, senior year, an awesome business law class. And it was just like the light bulb went off of like, I do love the engineering side. The economy was a bit weird in that period of time. And I decided I'm going to pursue law. I like being an advocate, and I did like the technology. That was quite some years ago. So legal tech probably wasn't even a thing to talk about. I don't think there was a phrase, much like there was an AI, 5-10 years ago. And that was really it. Probably the turning point was that business law class. That was just really eye-opening about how the law touches pretty much everything, regardless of industry.
That's amazing. And so if I remember correctly, you did your MBA and your JD almost simultaneously or in close succession or
Yeah. So my college career, admittedly, I did bounce around a little bit, trying to figure out what I was going to do, and ended up going to University of Pittsburgh in Pittsburgh, Pennsylvania, and they have an awesome engineering program, and I focused on industrial engineering there, which is a lot of what I sort of still employ in my practice now: process engineering, less so manufacturing, but really process engineering and efficiency. And after that, I went to Stetson College of Law in Florida, and they offered a dual degree program, which I ended up doing like 2.5 years because I'm a bit of a worker. And it was a great opportunity. It was pretty cool. I had a sort of a business law focus. Stetson's a great advocacy school, so it's a very practical education. All my colleagues, we come out of that school ready as you can as a young lawyer to practice law, not just sort of read about it in hypotheticals. So it was a cool opportunity.
that's amazing. So you completed an MBA and a JD in 2.5 years together.
Yeah, I guess so. I did a lot of summer school, and I don't tell anyone. I think there was a rule about working during that first year of law school about not being allowed to work. And I did do some working too. I worked in a law firm in Tampa. I remember early on. Yeah, it was. I think maybe that childhood thing of seeing my mom, how hard she worked, I think it sort of shaped the way I addressed the hard work that I had in front of me, which was to go to school, get the education, and want to start doing big things.
That's amazing. So not only do you preach efficiency, but you practice it too, clearly, because if you were able to crank out those degrees, super fast.
I try my best, but I've got two young kids, so efficiency takes different shapes these days. But yeah, I certainly I try to in my personal life too. I try to make the most, as many people do. Whether you're inundated with notifications and emails and messages, Teams, all this kind of stuff, I do try and efficiently get as much as I can, and even personally, like talking about working out, I try to really build that in. It's important for me psychologically, physically, to get that time in to exercise and to be the best I can do for work and my family.
That's awesome. So can you walk us through maybe your post educational career? How did you build your practice to where it is today? And then we'll get into some of the details.
Sure. Yeah. It's a short story, I guess. I did come out of school. I worked with a small boutique firm in Boca Raton, Florida, that did sort of traditional plaintiffs, personal injury. We had some really interesting cases, though. It was a really cool opportunity. We had a case go up on appeal to Fourth District Court of Appeal. I handled an excessive force case with a shooting on behalf of police. So it was pretty interesting cases. I was only there about a year, and then happened to come to, which is not a traditional change, went to this more defense-oriented firm, Roig Lawyers, and I've been there ever since. So I'm almost 18 years with my firm. I think when we got to roll back the history books, I think I was the eighth or ninth lawyer at the firm, and I guess it's a good sign that I've been there ever since. And it's been a great opportunity where my partners, we've all sort of grown the business together and really collaboratively built the business and the practice, with a lot of help from some technologies. But I have a great team. I mean, we're a good group of partners.
That's amazing. So you said when you joined, there were 8 or 9 attorneys in the firm. How many are there today?
I'm going to say around 40 lawyers.
Oh, wow.
So we're still considered, I guess, mid-size. Over the years, based on client demands and the economy, we've been significantly larger, but it's been pretty steady. And around the 40 to 50 lawyer spot seems to be a bit of a sweet spot operationally to keep delivering services, meeting client demands, having a manageable business, and keeping the firm's identity too.
Makes sense. How has your own practice and the areas that you focus on evolved since those early years to today? And how has the firm evolved also?
Yeah, it's a great question. So really, a lot of the firm's growth was really organic, which is a good way, I think, to grow. We didn't go out and not that it really exists in our business, but we weren't going out like buying ads or doing a tremendous amount of marketing. We probably did not enough marketing, 15 years ago. But really, we had worked with a small group of core clients, and we tried to really just service them and become a partner. That was our goal, was always that we felt, and I still feel to this day, that I'd rather represent a client for 15 or 20 years than represent a client on one instance and be treated like a vendor. We try to create symbiotic partnerships that are really results focused, goal oriented, and outcome based. And so the firm, we grew with inundation of litigation in Florida, mostly in the insurance and sort of first party space. As it spread throughout Florida, we were basically a South Florida firm. We organically said, oh, hey, we have needs up in Orlando, Jacksonville, Tampa. And we met those needs and opened offices in those locations. And then really the work changed. And I think for me personally, as I've gotten deeper into my career, the opportunities have arose to sort of do more of what I think I have more of a knack for and a skill for, working with businesses, sort of leveraging the risk management side. And it's been a great opportunity to sort of branch out and working with insurance adjacent. I always say sort of insurance adjacent. A lot of our work is working with insurance companies or on behalf of insurance companies, but that really everyone has insurance and everything is covered by insurance. So we represent businesses, professionals, anything you can think of, because typically there's insurance. But yeah, it's started organically, and then it's given us opportunities as it got wider to sort of hone our skills.
Within your 18-year trajectory within the firm, can you share maybe a couple of foundational cases that really shaped your thinking and how you represent clients, and the work that you decided that, hey, I'm good at this, my firm is good at this, and we should do more of this?
Yeah, one might be even somewhat recent. We were defending a business as a laundromat in a slip and fall type of accident. It involved really all aspects of our firm. This case was forging ahead to trial quite rapidly. It involved issues of potential medical fraud. We have an in-house, basically, special investigative unit fraud consultant, which was something that came about because that's what we realized clients needed in investigating injury claims and things like that. We leveraged the technology. There was troves and troves of documents, and it's incredibly hard, even with incredibly experienced paralegals and legal staff and our own experience. It's really hard to look at that data and then do continuous analysis and update that data and that kind of thing. So it was really like an eye-opening thing. And that was a more recent case about how far we've come, because I vividly remember being a young lawyer at the firm when we weren't paperless. Like, that's what's crazy. I don't feel that old, although I guess time passes and we are. But yeah, we went through a paperless conversion, and it was kind of a cool thing to see full circle how we leverage all these things, and the firm has grown to such an extent that we delivered such a good result, avoided trial, avoided exposure on behalf of a highly collectible insured in a pretty high multi-million-dollar case.
That's amazing. And I think that would speak to one area of efficiency that you mentioned, which is obviously a defining factor, I think, of your professional, even your personal life, as you mentioned. Can you maybe dive a little bit deeper into sort of the ways in which you leverage your analytical thinking, your knowledge of processes, both business processes and workflows, in two different areas? Obviously, one on the law practice side, meaning how you leverage technology in this particular matter, and I'm sure others. But then also in terms of how you advise businesses, or where do you see inefficiencies on their end that could maybe expose them to litigation or otherwise cause potential issues?
Sure. So yeah, I think when it boils down to it, I remember this industrial engineering, we did tons of queuing models. I remember through college, worked with grocery stores, or my capstone project was US Steel. And that really resonated with me, because everything can almost be boiled down to sort of this queuing models and identifying bottlenecks in your systems. Okay, let me caveat, assuming you have some systems in place. And I think that the legal industry and maybe older, I'm saying older, and like more traditional law firms weren't thinking that way, but we were, and we do. So it starts with the good processes, whether it's on behalf of advising a client for risk management or internally when we're handling litigated matters or just any kind of matter, whether it's transactional. Having good processes. And that starts from literally intake, initial contacts with clients, identifying witnesses, initial document review, and identifying what documents you don't have that you do need. And then sort of like the nuts and bolts, granular sort of document processing to get things going. Every time you take in a case, it's always like it's your first case ever. It's a really inefficient way of doing things. And I don't think that legal work, certainly what we're getting paid for, is the expertise, and that it's all gray. It's not always the same thing over and over again. However, if you conceptually threw all these cases on a whiteboard, at least your experience or 80% of what you see, there's commonalities between them. And you can take those commonalities and really map that out as this is what's really, those commonalities define what our process should be and who the people are we need in those roles doing those things, and what systems we need, what technologies we need in those things, and how we can sort of identify which ones of those are drivers, whether it's drivers of cost on our side. It doesn't create, even though it's capitalist, right? Like our firm makes money because we charge a fee. It does create friction, right? Like no one wants to pay a lawyer. Even large companies, we're still a large line item and we're sensitive to that. So identifying these drivers in that system lets us say, hey, look, they don't want to pay for that kind of thing. And we don't want to bill them for that kind of thing. How can we improve that and have this pay us for the legal expertise? So internally, that's how it's really, how we've leveraged a focus and mission of efficiency, is that that's cohesive and that's part of that partnership with a client. Is that they want efficiency, they don't want to pay us more, and they want to get to the result. And that's by sort of looking at this and saying, hey, where can we identify, here's our system, we know it's looked like this before, and then we can, of course, take the circuitous path whenever it's dictated. And I think the same thing, frankly, that's my advice for clients and for businesses of all sorts. It doesn't matter if you're a small business or massive businesses, good processes sort of determine good outcomes and help avoid risk. And I think it's hard to slow down. I guess here's a car thing, like a racing idea, right? They say slow to go fast kind of thing. Like you do have to slow down, I think, and do that kind of analysis in order to build on that efficiency. So, I certainly counsel clients all the time to let's sit down. I guess in my former life, maybe my second half of my career, maybe I'm more of a consultant, but it certainly has what a consultant would do. I'm doing it with the lens of the engineering side about efficiency, but also from the legal side of how are we going to avoid the legal risks that can come from not having those good processes.
That's fascinating. There's a couple of things in there that I want to touch upon. One is that I think there's a lot of discussion around quote unquote data-driven processes. And I think your example there of putting all the cases on a whiteboard or as many of them as you can, and then identifying commonalities, that is truly a data-driven process because you're letting the data tell you what you need to do as opposed to, some individual or some group sort of coming up with it and saying, hey, this is how it's going to be done. Is that a fair interpretation?
Yeah, that's fair. I will say the challenge is that, look, I can't speak to other industries, but if you're a fulfillment center and you're looking at speed it takes to basically move this product or product size on a shelf, those are really easy quantifiable data points. They're measurements, they're weights, there's time. When we do it is much more challenging because sure, there's time, but there's expertise. So let's say if a case comes in, we determine it's tiering it on complexity or severity. It's a tough consideration of, okay, how do we route this to which paralegal team or which paralegal is best suited because of her prior skill set or her experience or his experience, or which attorney team, or which one has capacity, which one has bandwidth to sort of handle this kind of client and their needs and their expectations. So it's absolutely data driven in that's what we're doing. We're looking at basically, as you said, the data is dictating our process. We're not sort of saying this is the way we've done it for 10 years. In fact, we say the exact opposite. If there's a better way to do it, I'm not going to keep doing what we did for 10 years. We want to find out the better way. Let's change. The problem, the challenge in our world is sort of figuring out the measurability of those things and then using it. That's our challenge. But we've been quite good at it. It's just, it takes practice and it takes interest in doing it.
It's very cool. When you started this conversation about efficiency and all the different elements that are involved in the workflow on your end, there's intake, there's document management, there's all the different things that you spoke about. For those attorneys or law firms who may not be as well versed in this workflow management and optimization as you are, what are some surprising or unexpected areas that drive inefficiency and that would be essentially low hanging fruit to sort of address first?
That's a good one. I think we've identified low-hanging fruit intake, to sort of taking in the matter, that data entry for initial stuff, that's certainly an inefficient process. You're transferring data from a document or documents from a client, whether it's a new client, repeat client, into your own case management system or CRM or whatever. The sort of clerical tasks are such time wasters when you're paying, highly skilled staff, like legal employees. These are professionals, and you're paying them to do, moving data over, transposing stuff is a huge waste. That, and I think the emphasis is on document management too. Again, I guess I'm dating myself, but it was always two-hole punching and using those Acco metal things. Put a paper and a file. And I remember as a law student, working in a law firm and typing up labels. It's really weird how far we've come. But I will say that even now with case management software, everyone in the year 2025 is well aware we're inundated with documents, emails, whatever it is. That's a huge time. It's a time sap. So developing good systems to sort of try to deal with email management and document management, I think, is another low-hanging fruit. It doesn't have to be that you have the silver bullet to fix it, but identify it. It's also an area of risk, right? You're getting 400 emails a day, and missing something is pretty significant. But setting up good systems, whether it's managing rules and Outlook, that's not super sophisticated, but probably something that I anticipate some firms that don't focus on things we're not even doing on a small scale.
Fantastic. I'm sure that's really helpful for some of our listeners. You briefly touched upon in data analytics. What sort of role has working with data analytics played in your career, and can you give maybe an example?
Sure. Yeah. So we definitely, as a firm, are big believers in data analytics. I guess, it's full circle, all those decisions and the flow charts and process improvement are based on data. It's not based on vibes, right? You don't go, oh, well, this seems like this is a better way to do it. Let's try it. Yeah, maybe there's some element of oh, we know this person can do this. Let's try it. But no, we're making decisions based on data. What we've done though too is sort of leverage what other data is accessible. One of my partners worked with an outside vendor to create a proprietary tool that we can search dockets and basically see what cases are being filed before they've even been served on defendants. So sort of for larger businesses that do see a lot of litigation, getting a crystal ball into what's coming down the pipe can provide some value. Internally, we like to keep track of cycle time. Again, that helps us in quoting rates and alternative fee arrangements with clients to other law firms. If you're not keeping track of this data, it's very hard to value the product that you're trying to sell. And it also it helps you become a better partner if you can actually say, hey, look, here's the expectation on day one. Here's how long this project or this case might be around based upon historical, data of other ones. That too, and just we're using the data of what we have obtained through other cases. I mean, my dream, right, is that we become the Google or the Amazon of what we're doing, and we can track all of the data that's in all of the individual claims, and of course, anonymize it to be able to make some decisions based on everything we have. Sometimes it's data overload, so we do take as much as we can. But again, we're a law practice. If I could stop practicing law and just maybe just be the executive and deal with data, then we'll get there closer. We'll see.
That's fascinating. You said a few very very interesting things, at least interesting to me in there. So one is by building that system that sort of looks at court filings before they've been served to defendants. Is that essentially like an early warning system that, hey, this is coming at you or potentially?
Yeah, certainly. So with our clients we partner with, I don't think we even charge for that kind of service. We offer it as like, it's a value add that we have access to this data and we can tell you, hey, look, this is a down month or like this is a very big month, and help them be more agile in their response to it. Obviously, there's risk in missing cases, but knowing what's sort of coming in. So yeah, it's really an early warning system to say, hey, look, yes, in the short term, these are cases that are pending service of process and are incoming, but also bigger picture to say like more environmentally, hey, what changed? Like, is something going on? Is it a groundswell of litigation? Is there a trend in our internal processes that have sparked litigation, or let them go back and give them another data point to sort of be more of a holistic risk manager, not just sort of looking in tunnel vision and saying, this is what we're doing, this is the way we've done it. It's just another data point to add to that analysis, I think, and it's proven helpful.
I can imagine. You mentioned value add, right? And so one of the other things, the second thing that you said after the early warning system comment was that it helps you track sort of how long things are taking, or what the duration and what the steps are. I would imagine that, for any sort of client, because it can be so much of a black box as to what is happening at the law firm, I'm sure that gives them a sense of visibility. And therefore, I would imagine that it provides a sense of assurance and therefore value that your firm is providing to them. Is that a fair?
Yeah, I think it's completely fair. Look, I think anyone that's hiring a lawyer, again, regardless of an individual or a large corporation, or anyone in between, you want communication and you want transparency, right? And I guess suppose results too. And the results, we take the case as it comes, so that we try to deliver the best result we can. But you can only do what you can with the facts and the law, of course. But if you have transparency of communication, there's no surprises. And when there's no surprises and a well-informed client, it creates for a really good partnership. And I think that's it. Yeah, certainly the value add I see is that it's an expectation level set from like the get-go. And we have the expertise. We've done this for a long time. The firm's been around 25 years. I've personally been there, almost 18 years. So we have the experience, but if we can also sort of point to the data and say, hey, look, this is what we're seeing, this is what the data shows, it gives more credibility to what we're doing. And certainly, I think maybe I am certainly biased, but, amongst competitors, I think we're thinking outside the box, and we're not just sort of saying, hey, look, sit in front of a computer, practice law the old way, because the old way doesn't work anymore.
That makes a lot of sense. In terms of out of the box thinking, no conversation would be complete without the elephant in the room, which is AI. So you're obviously spearheading, AI, the application of AI and many initiatives within your firm. Can you maybe talk through your role there? What are you sort of seeing? What have you implemented? And maybe just give us an overview of what's happening within your firm.
Sure. Yeah. So right, of course. I guess you can't talk about almost anything without mentioning AI. So here we are, of course. Yeah, I think the AI implementation, much like I laugh, paperless or any of our other sort of large tech implementations, I don't necessarily treat it as any different, to be very honest with you. I think certainly colleagues and industry wide and news wide, it's making waves, but it's like any other technology. And I think that a measured, calculated, controlled implementation is really, that's what I'm striving for with what we're doing. I was at a conference, I guess a couple of months ago. And of course, there's an AI session, as there always is at every conference. And the best metaphor, which I steal now from the speaker, was that, AI is sort of like the use of like a nail gun. You still need to know how to build a house, and you can swing the hammer and put the nails in and frame the walls, or you can use the nail gun, and it's going to be a bit quicker. It's going to be consistent, where you can adjust the depth, and it's going to help you get to like the conclusion that framed wall is going to be done a bit quicker, right? And I think that's been part of my implementation, is figuring out, how can we use it to, again, sort of improve our efficiency while still making sure that our expertise and knowing how to frame that wall and build the house is ineffective. At the same time, it's obviously, of course, is using good guardrails. So We operate within the constraints of all of our client agreements, our legal services agreements. Again, whether it's small or large. Most clients industry wide, I would say most are comfortable with the use of AI so long as it's meeting all of the privacy requirements and anything we've ever vetted and whatever use, of course, does. We're not using ChatGPT, those kinds of consumer grade products. So the security part's not a concern, but it's still putting up good guardrails to make sure that the people that are using it and the clients that we're using it with understand the expectations and understand the controls necessary when using a new technology.
Makes sense. Now, I would assume that you're still fairly early on in your implementation because AI is such a rapidly evolving field. But given even so, are there one or two examples of where you've seen maybe a pretty significant improvement in certain processes or even certain point solutions in terms of how they've helped you drive efficiency, in this area or that?
For sure. Yeah. Like, we are indeed quite early in the process as far as what I would consider, a full implementation. And I think that's intentional. I think it's very easy to flip the switch. It looks very appealing, but I think that the strength of the implementation is going to be in the control and processes and guardrails we put up when implementing it. So yeah, certainly in our implementation thus far, it's proving to be helpful. It's proving to be worthwhile and certainly is going to be adding value to the clients. So yeah, the best example, I think we've not yet really took the deep dive in generative. So producing work product, that kind of thing. But the immense benefit has been in sort of document synthesis and document review. So it's very routine. Certainly like e-discovery space, it's been going on for some time. It's really routine that we see 800 plus pages of medical records in injury cases. It's not uncommon at all. Most probably have more than that. Traditionally, there's a rule of a paralegal to go through those documents, try to create a medical chronology. You're looking for references to, comorbidities, prior injuries, inconsistencies in records. It's an incredibly laborious, time-consuming human task that even the best paralegals, it's susceptible to human error. With the aid of AI-assisted document review, you can get an initial cursory review incredibly quick. And I say initial cursory review because it's not the final solution. There's still a massive human element with that. But it gets you that first glance and that first analysis, which would have taken 20 plus hours in probably 90 seconds. And from there, it helps us focus into what we need to. So talk about efficiency instead of sort of reading of the 800 pages, 400 pages of visits to a primary care physician for, cholesterol issues, which we still have to read every single record. It's getting us to the meat and the important part that's moving the needle in the course of litigation. And I'm just using an injury case because that's a good example, but really it applies to all. And the other thing, we have a pretty large fraud practice, and that's been sort of a common theme in what we do, whether it's corporate litigation or injury claims and insurance work, has been fraud, whether, fraud with a capital F or fraud with a lowercase f, abuse. And AI has been incredibly useful. I think of like 100 years ago, you'd have duplicate medical records or whatever they were, and you'd put them on a projector on that clear projector paper, and you go, look, the signatures are the same, or these records are the same. And with these technologies, you can feed in enormous amounts of information and get trends from the data much more quickly. And then we can do our deep dive of what we do. So it's really helped to sort of pour gas in the fire of what we're already doing. It's another tool in our arsenal. That's how I see it.
Yep. That. Thank you for sharing that. That's actually a really sophisticated and nuanced view of how AI can be used. Because I hear this is just on LinkedIn and other forums, which who knows how much of that is true versus how much of that is clickbait. But it's either it's going to take everybody's job, or it's completely useless. And the truth, as with so many things, is somewhere in the middle. And I think the way you articulated it, Mark, which is that when used appropriately, with the appropriate guardrails, and we'll come to that in a second, it can actually be an immensely powerful tool to augment what you already do. And so I think that's a great way of putting it.
Yeah, absolutely. I think it's another tool. I mean, I think like look, we were wet signing documents and sending letters in the mail, and then the letter would get there 2 days later. Now we have email. It's speeding up communication. I won't get into whether it's made things better or worse necessarily, but yeah, it's another tool to help us do our job in a better way, and frankly, on the client side too, not pay for essentially sometimes granular tasks. We're still paying for the work that has to be done, but we're getting to the work that is moving the ball in a quicker, more efficient way.
Very cool. One final question on this, and then we'll start wrapping up. You mentioned guardrails a couple of times. For an attorney or a law firm who's thinking about an AI implementation, and maybe they're not as far along or as sophisticated as your firm currently is, what are some guardrails that they should be thinking about?
Yeah, so I mentioned it, legal service arrangements and legal service agreements. Firms deal with clients with incredibly diverse appetites for the use of AI and other technologies. It's incredibly important you line up those legal service agreements and that client is okay with the use of these technologies. Even though we've done extensive vetting of technologies that we're comfortable with, and we have our licenses and all these other things on the line, if the client doesn't agree to it, we have some very sophisticated clients that are not comfortable with it, you can't do it. So if you build something into your case management software, or you have a tool and you just turn on the switch and it's deployed firm wide, you are inviting some risk where if you don't have proper guardrails, where an employee can use it and you don't have that control. I think I've heard I think at another conference, someone said, okay, like let's say you have a client that doesn't agree with the use of AI. And you pull up Google and you type in your Google search. You're nodding at, so you know where I'm going with this. The top third of Google is a Gemini assisted summary of the response. So it's using AI. So like, do we have to turn off the Gemini assist in Google for the firm for risk that if someone's using one of the clients, it doesn't permit the use of AI? Like we have to consider those things, which I think that's my advice, I guess, to others that are going down this route. Consider those things, and you have to sit down and really think about it. So the guardrails to me are certainly legal service agreements, who's allowing it, and then I think too, the staff. So your team, I would say to make a measured approach to how you roll it out, because it is such a new tool. It's not a Google search. It's not a document assembly tool. It's something completely different. So evaluate your team and evaluate who is the most technical aptitude and who has that's something else that understands how to use a new technology. You can't use it blindly. You have to use it with your expertise, and who already has this sort of expertise to, as we sort of said, supplement what they're doing. That's, I think, what I mean by the guardrails, and my advice to others are going to go that route. It's not a thing we take lightly, certainly, it being so new. Look, I'm a sort of self-admitted first adopter. I like technology, but I'm certainly more sensitive with it when I have my firm and a lot of livelihoods on the line if we do something incorrect.
Makes a lot of sense. That Google example with the AI overviews is such a pertinent one, because it's like as it gets more and more, as AI gets more and more infused into various aspects of life, this blanket AI versus no AI is going to be a more and more complex conversation, I would imagine.
I think so. Yeah, it's everywhere. So if you have this client obligate you've agreed not to use it, it's going to be hard to avoid it. It's probably in everywhere, even using your legal research tools. There's AI assisted when it's natural language search. That's the best example for people that are really like sort of reluctant to adopt the new technologies. Well, we all did legal research in paper books. And then we had the advent of the LexisNexis or Westlaw, online search tools, but you had to use Boolean connectors to write those searches. And now it's natural language searching, which I suppose, is treading upon the use of language models to help you get better results. So all those things have built in efficiency. It takes time to build that comfort level using it. But yeah, I think it's out there. It's going to be hard to avoid.
Yep. Well, Mark, this has been a great conversation. Just to wrap it up real quick, we're obviously in this complex technological, social landscape, with AI and all the other things that we have around us. And so for a new attorney, maybe just out of law school, maybe they came out of a joint JD MBA program in 2.5 years like you, what advice would you give to somebody like that as they're evaluating how they should think about their career, and especially with all these external factors?
Sure. So this is probably going to be the answer you're not expecting. But look, certainly the technology, I don't think that the younger generation needs the advice of like, oh, no, the technology. I think they're coming up with it. I grew my career through it very literally with moving from paper to not paper. I think the thing that I would tell them, and I see, which maybe it's a common refrain, but it's incredibly important, is that this is still just technology that's supporting what we do as lawyers. And ultimately what we do as lawyers is still at its heart, human connection. It doesn't matter if you're connecting with a judge, if you're a litigator, if you're connecting with executives, you're sitting in a boardroom, or clients of any sort. It's that human element, the communication, empathy, that human element that makes you a tremendous advocate, whether it's advocating in a courtroom or advocating to a client, talking about their personal or financial or whatever that conflict is. They're relying on you as a counselor to get them through that situation. So the technology is going to be there. I'm not concerned about the use of technology. Perhaps don't rely on it too much, but certainly don't neglect to hone in those other human skills that, to your point, Aniket, like, the doom and gloom on LinkedIn and on clickbait titles of our jobs are all gone until it's completely, we're in like the year 2090 and there's flying cars and everything is automated. No, our jobs are not going anywhere. And these are just tools to help us do it. So my advice to those young crop of attorneys, don't forget what it is you do as an attorney and as an advocate and a counselor. The technology is going to be there, use it as a tool, but you still have to learn how to do the job.
Wise words indeed. Thanks, Mark. So final question for you. Is there a question that I should have asked you in all of what we discussed, but I didn't?
Oh, that's a good one. And I usually ask the same one in deposition. Usually I'm giving you the answer they give me, which is usually, no, I think you did a good job.
Thank you.
No, yeah, I think we really hit on all the big things. I think, you brought it up, but it's certainly a good point. Is AI going to change the world, and that there's going to be no more lawyers and our jobs are all gone and we should just wrap it up and hang it up? And no, the short answer is no, it's not going anywhere. The AI, this technology, it's provided another tool in our toolbox that, when leveraged properly, is going to create for better lawyers that can do more of the work that we should be doing, and better results for the clients because we can get to the work we should be doing sooner and more efficiently. If your goal as an attorney is to create a cohesive partnership with your clients and focus on the results, it's going to be a great, powerful tool. But I don't think that I don't think I need to polish my resume and look for something else because the AI is taking over.
Makes a lot of sense. Well, on that optimistic note, Mark, it's been a pleasure speaking with you. Thank you so much for your time, for the insights. I certainly learned a lot, and I'm sure our audience will as well. So thank you very much.
I appreciate it. It was a pleasure. Thanks so much.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.